Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-argument episode of SCOTUScast, Lawful Permanent Residency, Admission, and the Stop Time Rule Edition. I'm your host, Grace Gotchling. On November 4th, 2019, the U.S. Supreme Court heard argument in Barton v. Barr, a case involving a dispute over whether, for the purposes of the Stop Time Rule, a lawfully admitted permanent resident who is not seeking admission to the United States can be rendered inadmissible. The Stop Time Rule affects the discretion afforded the U.S. Attorney General to cancel the removal from the United States of a lawful permanent resident who has resided in the U.S. continuously for 7 years. Under the Stop Time Rule, the requisite continuous residence terminates once the alien commits any of a certain number of offenses that render the alien inadmissible to or removable from the United States under federal law. Thus, committing a listed offense may cause an alien to fall short of the continuous 7-year residence requirement and thereby become ineligible for cancellation of removal. Andre Martello Barton, after receiving lawful permanent resident status, was convicted in 1996 on 3 counts of aggravated assault, 1 count of criminal damage to property, and 1 count of firearm possession during the commission of a felony, all in violation of state law. In 2007 and 2008, he was also convicted of several state law drug offenses. The federal government then initiated proceedings to remove Barton based on his various convictions. He conceded removability on the basis of his controlled substance and gun possession offenses, but applied for cancellation of removal based on continuous residence. The government argued that Barton's 1996 convictions triggered the Stop Time Rule, thereby disqualifying him for cancellation of removal. The immigration judge ruled in favor of the government and the Board of Immigration Appeals affirmed. Barton then petitioned for relief from the U.S. Court of Appeals for the 11th Circuit, which rejected his argument that the Stop Time Rule only applies to aliens seeking admission to the United States, and therefore denied his petition. The 11th Circuit recognized that the Federal Circuit Courts of Appeals have split on the issue, however, and the Supreme Court ultimately granted cert to address whether a lawfully admitted permanent resident who is not seeking admission to the United States can be rendered inadmissible for the purposes of the Stop Time Rule. And now, to discuss the case, we have Amy Moore, Associate Professor of Law at Belmont University College of Law.
What does it mean to be rendered inadmissible? The definition section of the INA defines admission and admitted to be, quote, the lawful entry of the alien into the United States after inspection and authorization by an immigration officer, end quote. In that same definitional subsection, the statute says that LPRs should not be considered as seeking admission unless they meet several specified criteria, such as being absent for more than 180 days or engaging in illegal activity abroad, etc. At no point after being granted his LPR status was Barton ever in the position of seeking admission under this definition. So could he still be rendered inadmissible under the Stop Time Rule? The 11th Circuit answered this question in the affirmative, and in its opinion, the court agreed with the 2nd, 5th, and 3rd Circuits on this issue, but disagreed with the 9th Circuit. The 11th Circuit saw an agency in statutory interpretation and went right to Chevron. It said Chevron has been found to apply with full force when the Board of Immigration Appeals interprets ambiguous statutory terms in the course of ordinary case-by-case determinations. Chevron canonically has 2 steps if it is applicable. 1 is the statute truly ambiguous, and then 2 is the agency's interpretation reasonable. The circuit court found the language to be clear, so no deference was necessary. The lower court focused on the ordinary plain meaning of the word inadmissible to determine that Barton was inadmissible if he was not properly present in the United States. It then added a plain definition of renders that conferred a certain status on a person or object. For example, and one that came up at oral argument, a rotten piece of fish is inedible whether or not someone is trying to eat it. It has the status of being inedible that is conferred upon it by the rot. As a result, and a matter of both linguistics and logic, according to the 11th Circuit, merely committing the offense listed in 1182 rendered Barton inadmissible as a status and stopped his continuous presence in the United States. Therefore, he did not make it the full 7 required years and could not be eligible for cancellation of removal. This issue of status came up immediately during the oral argument before the Supreme Court. Justice Alito attempted to get petitioner's counsel, Mr. Unikowski, to agree that inadmissibility itself was indeed a status. Justice Alito compared the situation to evidence at trial, which would be inadmissible even before the attorney tries to admit it. Mr. Unikowski reframed the issue of inadmissibility as a status that attaches at a proceeding or an adjudication where an alien is found inadmissible instead. Here we have someone who committed an offense under 1182, but did the commission of that offense alone render him inadmissible, or would he have to be adjudged at some point, like entering the country or adjusting his status, to be inadmissible on that basis? Mr. Unikowski compared cancellation of removal to the mandatory detention language in Code Section 1226 or INA Section 236, where the Attorney General shall detain aliens who are inadmissible under certain sections or deportable under certain sections. There is a bifurcation or an analytical dichotomy. This same dichotomy appears in the jurisdiction section and, of course, in the cancellation of removal section. Justice Kavanaugh suggested that a better way to read the structure of the subsection was only to permit cancellation of removal for aliens with clean records, those who had not committed an aggravated felony or these other certain offenses within 7 years. His argument seemed to be that the commission of the offense made the alien the type of bad actor that Congress wanted to be ineligible for this type of relief. Justice Ginsburg also asked why Congress wouldn't want to stop the clock on these bad actors that commit certain offenses listed in 1182. Mr. Unikowski argued that because Barton was not deportable for his firearms offense, it was unlikely to be severe enough on its own to bar this type of relief. It seems like Congress left the door open. Later, Justice Sotomayor pointed out that the statute continually gives benefits and supports to LPRs, and it would be odd to walk that back on this one specific point. She also suggests it would be odd for Congress to say certain offenses can't get you deported, but they magically stop time so that if you're deported later for other reasons, you can't get relief from removal. The other problem offered with this bad actor structure that is discussed by the lower court and several times at the argument is the issue of surplusage. Remember that the statute stops time for the committed offense that renders the alien inadmissible or removable. The language does not simply say, if you've committed the offense, then you're ineligible, that's it. It says, if you've committed this offense and that offense renders you inadmissible or removable under these certain sections, you're out. So what work is the rendering language doing? It's a puzzle. But on this point, Mr. Unikowski says the government is inconsistent in its definition of the word inadmissible throughout the statute, and also that the government has abandoned Chevron because it was now pursuing a different construction than the agency. So this is now a case of the court being allowed to compare statutory interpretations on their own merits and not providing forced deference. In fact, the court never asks any questions to the government attorney about deference at all, and the court's history with Chevron deference in immigration cases is spotty at best. Mr. Unikowski does argue that according to Brand X, if Chevron doesn't apply, the only way for the court to insulate its own interpretation from future agency interference would be to say that it is the only clear one. Justice Kagan asks why the statute isn't split, where people who are inadmissible are subject to inadmissibility grounds only, and people who are deportable are subject to deportability grounds only. For some reason, Congress only listed certain offenses as barring relief and then conditioned that bar on those offenses actually rendering someone inadmissible or removable. Mr. Unikowski argues that this is because the rendering attaches to some proceeding where an alien is determined to be or concedes that he is inadmissible or deportable. The attorney for the government, Mr. Frederick Liu, focuses on a consistent definition for the word inadmissible across the INA. He argues that the statutory text does not require that an alien be seeking admission in order to be rendered inadmissible. Chief Justice Roberts calls these examples on consistency from the parties a wash. Justice Breyer really focuses on the surplusage argument and the extra language in the stop time rule about the committed offense rendering someone inadmissible or removable. Mr. Liu argues that it's not really surplusage, but in the alternative, as the justices move him along, the court should not rely on surplusage in its construction of the statute. Justice Kagan admits that surplusage sometimes gives way to other things, but refocuses on the dichotomy of the entire INA between inadmissible and deportable. The or language is disjunctive. The government's response is that Congress listed many offenses in 1182, but also listed exceptions to those offenses so that committing an offense does not always render you inadmissible. So when Congress said committing an offense in the cancellation of removal section, those exceptions may not have been imported as well. The remedy was to say only if an offense in 1182 was both committed and under that section would render you inadmissible, that is, did not trip an exception, would it count against you at the relief stage. Justice Kagan did not appear to be persuaded. Justice Breyer also noted it was impossible for Barton to be inadmissible because he was properly admitted. Justice Alito later responds by saying this is a lot like taking someone to the hospital for eating rotten fish and saying the fish could not have been inedible because it was actually eaten. In the rebuttal, Mr. Unikowski argues the meaning of the relevant words should be compared to the statutory language that was passed at the same time in the amendments. He also argues for the application of the canon of surplusage, as the statute creates two buckets, as he calls them, one of inadmissibility and the other of deportability, separated by that disjunctive and meaningful.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.